We have one counsel. Now we need our other counsel. Okay, we have everyone. One illuminated, and Mr. Miros, you are not quite totally in the dark, but it is dark screen behind you. We are ready to proceed. Attorney Grossman, I believe you represent the appellant in this matter, and did you wish to reserve any time for rebuttal?
I do, Your Honor, 4 minutes.
Okay. Thank you. And with that, hold on a second. You may proceed now.
Good morning. May it please the court, Jane Grossman on behalf of Mr. Kalki. I will refer to Mr. Kalki as the husband. We've raised a number of issues in our brief, which we believe relate to an abuse of discretion. And primarily all of those stem from what we believe to be the court's abuse and failing to grant Mr. Kalki a continuance. Sorry, I got a little distracted. As to the continuance issue, we've urged that the failure to continue the trial, the final hearing in the divorce, resulted in a grave injustice to Mr. Kalki, the husband. And we must demonstrate, we believe we have, that the injustice to the husband outweighs the presumption or the policy of not wanting to disturb the trial court's ruling. Here, we've cited a number of examples of injustice to the husband. Neither party had requested a continuance prior to the scheduled final hearing. It was scheduled in March of 2020. All of the trials in the courthouses were continued due to COVID. It was rescheduled to September, continued at the court's own request, and then rescheduled to the 3 days where the trial occurred. No finding was made by the judge that Mr. Kalki was dilatory in attempting to find.
Oh, Ms. Grossman, I think it's pretty clear why the trial court ruled the way it did. One of the reasons was because at the previous hearing, at the motion to withdraw counsel, the court made it very clear that we're still going to trial on these dates. Then Mr. Kalki didn't move for a continuance, as you point out. Instead, the claims on appeal are, I walked in that morning thinking we were here for a hearing on my motions, when actually it was here for trial. But in the same breath, you're arguing, well, I didn't find out until a week earlier when I was served with the exhibits that we were going to trial. And then, there comes a, and then, oh, and by the way, that whole week I was in bed with COVID. I mean, after a while, we get to the point of, well, the dog ate my homework. And given all of this, given everything that had transpired, and given what the court said on the record, I'm having a really hard time second guessing the trial court's evaluation of what was going on here.
Well, I can't disagree with the trial court's statements. I can't disagree that there perhaps is some, at best, confusion on Mr. Kalki's part, at worst, lack of credibility as to why the final hearing should not proceed. But the court is the ultimate gatekeeper. And when you have the parties show up and the marital estate is valued at $3.5 million, there's a claim for permanent alimony, there should be an exercise of caution regardless of the behavior of one of the parties. And that's where I'll get into the issue of prejudice to the wife if the final hearing had been continued, or if this court were to allow a final hearing to be heard de novo.
Well, I think the prejudice to the wife was also pretty clear from the record, in that, one, she was there for trial, ready to go. Two, this had been dragged out for quite some time, a number of years already. And throughout the entire period, the wife was constantly having to file motions to enforce the temporary agreement between the parties. So I think the record establishes a prejudice to the wife too, if this were kicked down the road any further. I appreciate what you're saying, that of course, under the best circumstances, we want to give a party the opportunity to fully and fairly present the argument that, he's going to make and present his evidence. But at a certain point, the party brings the results on themselves. And I don't know why on this record we would be able to conclude that the court abused its discretion in saying, you know what, this is the point where that has happened. To the extent Mr. Kalki is precluded from fully making his arguments, at this point, he's brought that on himself and he's got to live with the consequences.
Well, Judge, I respectfully disagree. There are cases where parties have requested continuances multiple times, and then you reach a point where you say enough is enough. Mr. Kalki, neither party had ever requested a continuance. Even if you get to the point where we say, okay, we're not arguing anymore about whether or not we're proceeding with trial. At that point, Mr. Kalki deserved the same type of due process that would have been afforded an attorney who was there representing him. For example, on the very first morning of the 3-day scheduled trial, he said to the judge, "Judge, may I call my forensic CPA as my witness? I have a forensic CPA." And the judge says, "Sure, you call him right now, even though there was 3 days of trial." Now, had he had an attorney and an attorney said, "Your Honor, we need to hear from our forensic CPA later on in our scheduled time or tomorrow during our scheduled time," would that be an issue? With no doubt, the judge would have said, "No problem, it's your time, you schedule your witnesses when you can." But to have a judge say to a litigant, a pro se litigant, "You call them right now, get them on the phone right now." Clearly, that was an abuse of discretion, and that behavior would not have happened if he had an attorney. He had a business CPA that he wanted to call. When he asked the judge, "Judge, may I call my business CPA?" he was met with a technical objection from the other side. "Oh, wait, the business CPA is not on the witness list," which I understand, a technicality. But at the same time, the wife and her attorney are having one witness testify at the final hearing, the CPA. The CPA did not lay any foundations as to its valuations. Neither party testified as to any values of any of the $3.5 million of the marital estate. It all came from the CPA with no foundation, hearsay upon hearsay. None of that was objected to, and the trial court, as the ultimate gatekeeper, never did anything to say, "Excuse me, CPA or attorney, this is based on Blue Book values. Did we waive records custodian? Your valuations are based on residential appraisals. Where are the appraisers so that Mr. Kalki can cross-examine them if he'd like?" None of that was done. That would never have happened if Mr. Kalki had an attorney. Mr. Kalki, during the first morning of the trial, said to the trial judge, "Judge, I would like to take these exhibits and review them tonight and conduct my cross-examination tomorrow." And the judge says, "No, you're not going to do that. You either do it now or you're not going to do it at all." That's unheard of. If he had,
That's because he supposedly had gotten the exhibits the week before, correct?
well, does it really matter though, when you have a 3-day trial and he has a day and a half of that to use as he wishes? If he wanted additional time to cross-examine, when we go to trial, it happens all the time where we say, "Judge, I would like to defer my cross-examination until my case in chief," and it is routinely granted without any objection. There would have been no harm to say, "Mr. Kalki, yes, you can conduct your cross-examination tomorrow or even on the 3rd day." As it was, they finished this final hearing in 3/4 of one day, and 2 days were left unused. That is a prime example of an injustice that should not have happened and would not have happened if there had been a final hearing. There was a pending motion for a vocational evaluation of the wife. She had agreed to it. It was court ordered. She never underwent that. Mr. Kalki filed a pro se motion to compel. By all means, that should have been considered prior to any alimony determination. As it was, the wife was awarded permanent alimony in a moderate term marriage of $90,000 a year. That vocational rehab evaluation should have been conducted, and the fact that it wasn't was yet another example of a grave injustice to Mr. Kalki. Like I said, all of the evaluations were provided by the CPA. Only one witness was called by Mrs. Kalki. When you talk about prejudice to the wife, let's ask ourselves, if this case were continued and kicked down the road 6 months, what prejudice would have happened to her? I understand what you said, but she was receiving nearly $8,000 per month in alimony. She had possession of a home. She was working full-time. Her attorney's fees were being paid. And if this final hearing were continued to another day, any additional work that her one and only witness would have incurred, or her attorney's fees, could have most certainly and should have been addressed at a fee hearing. If they incurred additional attorney's fees because this trial had to be rescheduled, then by all means, Mr. Kalki should be required to pay those. And I stand by that. As it now, she is still receiving each and every month her alimony. The final judgment was stayed by the trial judge because number one, it was repressed, but number two, the trial judge made a determination that we have demonstrated a likelihood of excess on this appeal. So I beg to differ with you, other than the aggravation of having this go on another 6 months, there absolutely was no prejudice. And I would like to say too, the wife in her brief spent most of the time reciting allegations. And I'd like to point out those are allegations of his misconduct or his poor behavior. Your Honor, if only well-behaved litigants were allowed due process and to have their day in court, our divorce courts would be completely empty. We would not be having any trials if everybody had to be well-behaved at all times. And I understand that due process must be meted out evenly, whether the marital estate is $100 or $1 million. But in this case, when you have a 16-year marriage, the marital estate is $3.5 million, and there's a claim for alimony, which I would like to get to. Do we not owe the litigants a fair day in court and mete out whatever consequences to Mr. Kalki should happen at a later time? When you read this transcript, when we read this transcript, it appears that this was a one-horse race. And Mr. Kalki was completely in over ahead. And like we stated in the brief, you have to ask the question, he's an acute businessman. He understands the value of these marital assets. He understands there's a claim for permanent alimony. And why would he intentionally show up at a final hearing without his forensic CPA that he had engaged and paid, without an attorney, if he truly did not think that this was going to proceed? Now, was that belief based upon his own ignorance? Was it his fault? Probably. And should he be punished? Should he receive merely the value of his business, valued solely by the wife's CPA, while the wife receives 3 homes, the yacht, the slip space, 3 cars, including 2 Porsches. She gets all of that in $90,000 a year in permanent alimony, and he gets the value of his business, basically. Unless the court has any additional questions on the continuance issue, I'd like to move on to the issue of the permanent alimony that was awarded to Mrs. Kalki.
As you proceed, I will give you kind of you're at 14 and a half.
That was quick.
Time flies.
Quick.
Yes, it does. On the issue of the alimony, I would like to point out that this case cited the, or wrote the Taylor opinion, which is cited in our brief. And it talks about how very important it is for the trial court to clarify in its final judgment exactly why it's awarding the type of alimony that it is and the amount. And this is not clear in this case. We've pointed out in the record that in her oral ruling, she just states this is an 18-year marriage. I'm awarding permanent alimony. It's a long-term marriage. And Mr. Kalki says, 18 years. And she says, yes, this is 2020, isn't it? And moves on to other findings. Later, it occurred to her that this was really only a 16-year marriage, but she never went on to address overcoming the statutory presumption that this is a moderate term marriage, justifying durational alimony only. She never clarified that she did not consider this still to be a long-term marriage. There's confusion in the record, which says to us, the readers, did she understand the law and did she just misapply the law? And that needs to be clarified. And I would ask the court to also consider the life insurance and her failure to make a finding as to the net incomes of the parties. I mean, the case law is absolutely clear that this is required. She made a finding as to gross income, but never made a finding as to net incomes. Thank you.
All right. Mr. Miros, you may respond, counsel.
Good morning, Your Honors. I have empathy for Ms. Grossman attempting to explain and or excuse the actions of Mr. Kalki during the course of this matter. But they are not excusable, number one. And number two, they are definitely not the fault of the trial judge here. Not only did the trial judge do everything reasonably possible from day one of this filing to get the case to trial, but she made it as clear as a bell 6 months prior to the trial date, the case was going forward as scheduled in November. Mr. Kalki not only had the benefit of 3 fine lawyers, all of whom are referenced in the record, but he also had the benefits subsequent to the last attorney withdrawing of contacting 3 other lawyers concerning his representation. I would suggest that if you were allowed, after having 3 lawyers and then contacting 3 other lawyers, to simply show up at trial and claim that you didn't know the case was set for trial, would shut down the judicial system in its entirety. How much better of an example could you have of prejudice to one party when they spend all of their time and their money and their emotions preparing for trial as per the trial court's order, and have the other side show up and say there's no trial set? I'll be very brief on this issue because I think everyone's dealt with it well. This was a matter of not only Mr. Kalki simply not obeying the trial court order after not having obeyed many of the temporary orders during the course of the case. It's him directly misrepresenting the facts to the judge related to why he wasn't ready for trial. He goes from one excuse to the other and then finally makes one up at the end that he was sick. This simply should not have been tolerated by the trial judge and wasn't tolerated. Now, the argument that somehow he didn't have an opportunity to produce his evidence, for example, why wasn't the vocational evaluation dealt with? These are all things that should have been dealt with prior to trial by Mr. Kalki and were not, for whatever reasons. I don't know why, but certainly not our fault. He had every opportunity to present his evidence. He simply didn't prepare for trial, whether it be pro se or by a lawyer. He had a forensic CPA. He just didn't have that person there or ready for trial. It wasn't my fault. It wasn't Judge Newton's fault. It was his fault, 100%. The only competent substantial evidence before the court entirely supports the ruling and certainly supports the denial of a continuance. There are so many other examples related to that, but I'm not going to dwell on them. I think we've covered them. Let's now deal with the permanent periodic alimony award. I respectfully submit to the court that the trial court's award is not just supported by competent substantial evidence, but is supported by the only competent substantial evidence before the court. The law, the statute itself, and or all the case law we've cited clearly supports the entitlement to an award of permanent periodic alimony with a moderate term marriage if you provide the appropriate evidence. I hear the judge did specifically find with good reason that no other form of alimony was appropriate other than permanent periodic alimony. And the very clear and very convincing evidence supports that finding. Here, the facts were, again, undisputed that Mrs. Kalki was a 47-year-old woman who was an immigrant from Venezuela, who had very limited job skills, who was earning $17 an hour at the time of the final hearing, who had no identifiable rehabilitative plan, no ability whatsoever to support the marital style of living going forward. And very critically, that she was earning $2,200 a month, and he was earning, by the undisputed evidence, $40,000 per month. She had no chance of ever being able to support herself in a reasonable standard of living going forward in accordance with the marital standard. It's also critical.
Mr. Meros, let me interrupt you there because there is something about that that's troubling me. The numbers that you just quoted, my understanding, are the gross income. And I understand that you were just quoting them to show the sort of generally the ability to pay and the need for alimony. But my understanding of the actual alimony calculation is that it was based on Exhibit J.
That's correct, Your Honor.
And I'm not, help me work through this because I'm not sure whether your argument on appeal is that Exhibit J properly calculated alimony based on net income, or whether your argument is, well, it's not really clear if it was based on net income or gross income, but at the end of the day, it doesn't matter. And so I want to be very clear as to what the basis, what your argument is, because I agree that there are no findings with respect to net income, certainly not in the final order. And I'm having a little bit of a hard time sort of working my way through Exhibit J to make clear exactly what happened.
Sure, let me do that with you, Your Honor. And let me say that the award is definitely based on net available income. If you look at our Exhibit J, if you have it available, and it is in the, we particularly made it a part of an appendix so it would be easily findable. And it's A12 of the appendix. And this is the way that we always prepare these documents, and it's the right way to do it. And it is very explanatory. What the document does is first identify gross income. If you'll see at the top under the husband, his gross income was $40,961 a month. The wife's was $2,210 a month. You then back out the alimony of $7,483, giving him income after alimony, but before deductions, of $33,479. We then back out all of his entitled deductions, his taxes, Social Security, his health insurance. And as you will see, and this is the reason we call this document what we call it, the available net monthly income to each of them and is $21,101 to the husband after all deductions, and $9,097 a month to the wife after alimony and income and all deductions, which in the bottom column shows that it meets her need and shows that he has a surplus of $9,983 a month. Our numbers are 100% totally based on net available income. Gross income is on there because it has to be, but it's a net available income analysis.
So is the 21,101 his net? That's not his net income before alimony. That's with the alimony taken out of the gross income?
Yes, ma'am. It's showing the his total net available income after all of his deductions. This is
After all of
based,
his deductions and alimony?
yes,
are taken
ma'am.
out? Okay, so
After
you're
it.
taking the alimony out of the gross because of the tax implications, or to account for any tax implications? There
Well,
wouldn't be
yes,
any,
you
is your
have to
point?
take, yes, ma'am, you have to take the alimony out of gross for this spreadsheet, for this calculation, because that is then going to determine how you arrive at his deductions. So this is based on the theory for all of the case law related to net versus gross, is that for purposes of determining where people stand, you have to use net numbers. You can't use gross numbers. And that's what we did in this document.
Okay, so if we wanted to very simply find out what his net income would be before alimony was taken out, we would just add the 21,101 plus the 7,483.
Exactly.
Okay, so even though there's no express finding as to his net income to determine whether alimony could be taken out of it, that's obvious from the exhibit.
Yes, and the exhibit was accepted by the court and referenced by the court specifically in the final judgment and in the transcript. It's the only evidence before the court, and it's supported by competent substantial evidence in all respects. I remind the court that Mr. Berg not only testified and explained all of this, but our trial documents have all of the backup. It has all of the expenses, all of everything, financial affidavits, full backup for everything. So my comment related to there being no abuse of discretion here is that we established that this is the only fair way to deal with this alimony claim going forward. And what it does is gives Mr. Kalki the entire ownership of a business that has grossed an average, that has had net income to the family. And by that, I mean income payable to the family before taxes of $500,000 a year for the last 3 years. He's left with the entirety of that, with his only obligation being paying alimony of $7,700 a month, and then a substantial excess over and above that. This is a situation where the result by the trial judge, in accordance with Kanakaris, clearly did not transform either party from prosperity into misfortune. I'm not sure how much time I've used, but I can briefly deal with the life insurance if you wish. The life insurance, all the findings
10
were.
and a half.
Okay, great. The life insurance, all the findings were there that should have been there. And contrary to virtually every other case, this was an existing life insurance policy with an existing premium that insured the husband's life for $1 million, clearly identifiable. The court found special circumstances, which here were pretty obvious, is complete failure to comply with prior court orders, and that he got the entirety of the business, which upon his death would have left no ability for her to receive her alimony or support herself going forward. The imputation of income argument is completely without merit. They're claiming that the court should have imputed income to my client when she received no liquid assets whatsoever. She received the home, some real estate, and no liquid assets, and all of the case law, contrary to their argument that you should consider all of the assets for purposes of imputation, is just wrong. It's only assets that are available to impute income. And that's
Was there evidence in the record that the rental properties were operating at a loss? I thought I remembered reading that somewhere.
Yes, there was. There's no evidence as to the specifics, but there is definitely no evidence of any receipt of income from the rentals. And of course, the big thing here is that cannot be overlooked is Mr. Kalki didn't present any evidence of what the imputed income should be, if any. He presented nothing, nothing whatsoever. So to make a long story short, and the last comment I would have is the council made points about all we did here was offer a CPA, and that's not really fair to this gentleman, and it's not really competent, substantial evidence. Well, we offered very specific, straightforward testimony by a highly qualified individual with all of the backup, identifying each and every issue before the court, buttressed by all of the backup documents, and buttressed very much by the testimony of Mrs. Kauke. There is not one finding here that is not completely supported by the competent, substantial evidence before the court. This gentleman had every opportunity to present evidence to the contrary and simply failed to do so as a result of his own dilatory conduct and neglect, specifically in accordance with his behavior throughout the course of the entire trial. The ruling should be affirmed. Thank you very much.
Excuse me. Attorney Grossman, you have your 4 minutes for rebuttal.
Thank you, Your Honor. If we were only here on one issue, and that issue was our complaint that Mr. Kauke was denied the opportunity to present the testimony of his forensic CPA during his allotted time, this would require reversal. This forensic CPA was critical not only to the valuation of the marital assets, but Mr. Kauke had a claim for non-marital assets, which he consistently listed on his financial affidavit, in excess of $1 million. To deny him his one witness who could clarify that and present testimony requires reversal. It would have never happened if he had an attorney or an attorney made that request. He should have been allowed to cross-examine Mr. Berg, the CPA. The fact that it did not happen is reversible error. He had the time allotted. He should have been able to use it. And I take umbrage with my respected opposing counsel when he says the testimony of their CPA was factual and this and that. It was not. It was based upon hearsay on hearsay. Mr. Berg was allowed to testify as to what somebody in Mr. Kauke's office told him, and then he testified to that before the court. Their residential appraisers reports would have never been introduced into evidence if Mr. Kauke had an attorney and knew how to address those evidentiary objections. And that's addressed in the case law. Whether or not his lack of skill greatly impacted the result that was meted out. So we can say Mr. Kauke acted, poorly. We can say he did not tell the truth. We can say he was a cad. We can say he was this. We can say he's that. The bottom line is, forget all of that. If he showed up that day and never made a complaint about moving forward, and he was denied the right to present his forensic CPA, that is error as a matter of law. And it should not be allowed to happen simply because he's a pro se litigant. On the issue of the alimony, again, the trial court's statement, no other form of alimony is appropriate. I'm sorry, that is not sufficient under law. The law requires that there be findings of fact. This statement that the wife is entitled to permanent alimony and no other form is appropriate, that's a legal conclusion, and that does not meet the specifics of the statute. As far as Mrs. Kauke.
Before we leave that point, that subparagraph that's a subparagraph of what? Paragraph 6, where that appears, where it says is the only appropriate form, that's subparagraph F. But there are 4 to 5 paragraphs immediately preceding that, laying out a whole number of facts. Is that sufficient to support the conclusion? And I will note there's no number 7. Well, yeah, there is on page 5. It goes, oh, that's a G. I dropped my glasses today and they're little warps. Okay, that's not an 8, that's a G. Okay, so there's a number of paragraphs in 6 where she discusses that.
Well, she never discusses, number one, she never states that this is a moderate term marriage. She doesn't make any findings of fact which justify deviating from the statutory presumption. She makes findings of fact as to the difference of the incomes and things of that nature, which is required under 61.08. But if you're going to deviate from the statutory presumption of durational alimony, you have to make findings of fact, and simply saying durational alimony is not appropriate is not a finding of fact, that's a legal conclusion.
She has no reasonable plan for rehabilitation or additional education and did devote her time and energy into this business.
That is not a finding to justify PPA. And when we're talking about education, I'd like to point out that Mr. Kalki too is an immigrant. The English language is not his first language. He was at the same disadvantage as she was. So to portray her as poor Mrs. Kalki, who can't find her way in America, is simply not an accurate representation.
Well, I think that's sort of exaggerating what the trial court found. The trial court found that she was a 47, I think, year old woman who had spent her career working in the business that the two of them had built together. She had a high school education from Venezuela, and she was working basically as the office administrator. And so I don't think, I think you're sort of exaggerating the court's very fact-based findings and support.
Well, Your Honor, when you read the findings of fact that the judge sets out to support the $7,500 per month in alimony, it's very clear that it's tied to a disparity of the incomes. She will no longer be working in the business. And the case law that we have cited makes it abundantly clear that disparity in incomes alone is not a justification for permanent alimony. And we completely ignore the fact that she was awarded $3.5 million in assets, or excuse me, 1/2 of $3.5 million in assets, multiple homes that she can sell. She can sell a yacht of $150,000, multiple cars. This lady by no means was left destitute. The husband, on the other hand, was awarded a business which was, the valuation was relied on, the trial court came solely from their CPA, which is another reason why the forensic CPA should have been permitted to testify and clarify what their opinion of the marine construction business was worth. Because as it was, they lumped up the marine construction business on one side and gave the wife all of the other assets based upon their valuation and their valuation only.
Thank you, Counselor. We are well beyond the time that you reserved, almost
Thank you
double.
very much.
Thank you all for your presentation today. We hope that you all stay well, and will allow you to be transferred over to the departure facility, if that's a good phrase. I don't know.
Thank you.
According to my clock, it's 11:33. We're going to take a recess. We will be back at 11:50.